The Oil Rig Safety Blueprint. How to win your maritime injury claim in 2026. Working on an oil rig remains one of the most dangerous jobs in the world. Whether you are off the coast of Louisiana, Texas, or working in the harsh conditions of the North Sea, the risk of a catastrophic injury is a daily reality. But what happens when the safety protocols fail and you are left with life-altering injuries? The road to recovery isn't just medical, it's a high-stakes legal battle. Big energy corporations have massive legal teams dedicated to one goal: making sure you get the smallest payout possible. Today, I'm giving you the ultimate masterclass on oil rig injury law, the power of the Jones Act, and how to hold these billion-dollar companies accountable. The first thing you must understand is that injuries at sea are not treated like typical accidents on land. In the USA, maritime workers are protected by a powerful federal law known as the Jones Act. This isn't just standard workers' comp. Under the Jones Act, if you can prove that your employer's negligence, even by 1%, contributed to your injury, you are entitled to damages that include medical expenses, lost wages, and pain and suffering. However, the window of opportunity to file these claims is narrow, and the companies will often try to pressure you into signing maintenance and cure documents that waive your right to a full lawsuit. Never sign anything without a maritime attorney present. In 2026, negligence on oil rigs often stems from equipment failure, lack of proper training, or ignoring weather warnings in pursuit of profit. When a blowout, a slip and fall on a slick deck, or a crane accident occurs, the evidence starts disappearing almost immediately. This is why the first 72 hours are critical. If you are injured, you must report it, but be very careful about how you describe the incident. An offshore company's safety officer is often looking for ways to blame the victim. Your best defense is a maritime specialist, who can send a team of investigators to the rig to preserve evidence, interview witnesses, and download data from the rig's monitoring systems. Let's talk about the financial reality of a settlement. Because oil rig injuries are often permanent, back injuries, limb loss, or severe burns, the settlements in 2026 are frequently in the 7- and 8-figure range. But to get that amount, you have to prove the long-term impact on your life. Big oil companies will hire private investigators to follow you and check your social media to see if you are truly injured. A specialized attorney will bring in vocational experts and life care planners to calculate the exact cost of your care and lost earning potential for the next 30 years. This is how you win a case that secures your family's future. Choosing the right attorney for an oil rig case is different from hiring a local car accident lawyer. You need a Proctor & Admiralty, an attorney who specializes in maritime law and has the financial muscle to go head-to-head with companies like BP, Shell, or ExxonMobil. These cases are expensive to litigate, and your law firm needs to be able to front the costs of expert witnesses and deep-sea investigations. Don't be swayed by flashy ads. Ask about their specific success rate with Jones Act claims and their experience with the Longshore and Harbor Workers' Compensation Act, if your injury happened on a pier or dock. Ultimately, your life and your health are worth more than any company's profit margin. If you've been injured offshore, the law is on your side, but you have to be the one to activate it. Take action today by documenting your injuries, staying off social media, and consulting with a specialized maritime lawyer who knows the industry. If this breakdown gave you the clarity you need during a difficult time, share it with your crewmates or someone who's fighting an offshore legal battle. Remember, when you're up against a giant, the law is your